A very good afternoon to one and all present here. Welcome to the second day of International Conference on Aquatic Literature. I, on behalf of Speaker College, Amalgiri, and Cape Comorin Trust, we are really pleased to welcome research scholars and paper presenters from various parts of the country. Let's move towards our first lecture of this session. So, we are pleased to have Dr. Shalini Kashmiria, Assistant Professor, Department of Laws, Himachal Pradesh University. She has numerous publications to her credit. She has done a project on tribal communities of Himachal Pradesh. So we are delighted to have you as the keynote speaker of the day. It's my pleasure to welcome you, ma'am, for an amazing session.
Thank you, dear Ashisha. First of all, I'm very much thankful to the Cape Comorin Trust for giving me this platform to share my views with you. And I must congratulate the host college for organizing such a good international conference on such an important topic of the present century. And time and again, we talk about it, we listen about it in the newspapers and in on the TV channels also. My very first thing is my PowerPoint presentation is visible to everybody. Is the PPT visible?
Yes, ma'am.
Yes, ma'am.
All right, all right. So the topic that I have taken is aquatic legal literature of water in India. So when we are going to talk about the aquatic legal literature, the most important topic that we can discuss from the law point of view is the water management, how this water management is taking place in India, how it developed before the European colonization, what were the policies and what were the laws, and what kind of changes have taken place in it with the passage of time as the centuries passed by. So my very first thing, which I'm going to talk to you about, because I know maximum of you are not from law background, so I have made it a very easy kind of presentation so that a common man can also understand it. So the very first thing that I'm going to talk to you about is why the water laws are so important for us right now. If we take a look towards the demography of India, we will see that our continent is surrounded by sea from three sides. On west, we have the Arabian Sea. On the south, we have the Indian Ocean. On the east, we have the Bay of Bengal. And on the north, we have the mighty Himalayas. And if we take a look towards the area of our country, we'll find that we have approximately 3 million square kilometer wide area. Our continent is spread in 3 million square kilometer. And if we talk about the Indian population, right now the Indian population contributes to about 1/6 of the world population, is the home of our continent, is residing in India. The most important part is that beside being surrounded by water from three sides, we have rivers, and 12 major rivers are running across the different states of India. And every year we have the flood-like situations because we are uniquely blessed with the different kinds of seasons, 4 kinds of seasons we see in our country. So we face different kinds of flood-like situations during the rainy seasons. And if we talk about the total consumption of water in India at the moment, as we all know that we are an agricultural state, and 85% of the water is being utilized for agriculture purpose. 8% is for domestic purpose, household purpose, common man is using it in their homes. And 5% is being utilized in the industries. And as this urbanization and industrialization increasing, definitely, yes, this 5% is going to increase with as the time will pass by. So switching over to the next slide, when we talk about the legal literature of water, we have different kinds of things coming in our mind at that time. So when we are dividing, we are trying to divide it, we will see that we can, for the convenience of understanding, we can divide it into 2 kinds of history. The first one is the pre-colonial history of water laws before independence. And the second one is the post-colonial history of water laws, that is after our independence. So when we talk about the pre-colonial history of water laws, we have the historical context in which we will be talking about the Indus Valley civilization, Mahabharata, and the various kinds of Hindu textures which were written, what they were talking about law, what they were talking about the laws related to water, and then what Hinduism was talking about it. And then when the Mughals invaded and Islamic invasion took place around 10th century, what were the Islamic water laws? And then when the Europeans invaded India, what kind of changes were brought in the water laws? So when we talk about the pre-colonial history, that is around 2500 BCE, approximately 16th to 17th century, the very first evidence, although these evidence are not all the evidences are not available, it is very patchy, but whatsoever remnants we have of our ancient civilizations, the most important that we have seen is the Indus Valley civilization. And this civilization took place around 5000 years back on the banks of Indus, and it was considered to be very rich in its cultural heritage. And still, people go and see that there are great baths in Mohenjo-daro civilization which are still present, which shows that how they used to channelize water, how these water channels in these great baths were going to and from. So people were aware about the utilization and the canal, kind of, you can say, canal system was there of water utility and water movement. So switching over to the next slide, after the degradation of the Valley civilization, and when the various invaders invaded India, and they basically conquered various parts of a country, and they invaded India for the purpose of gathering gold, and for the purpose of, because they were not very settled kind of lifestyle invaders, they were basically for the purpose of gathering theft and kind of robberies, kind of intentions were there inside their mind. But the very conspicuous part of it, maximum of them were Europeans. And this European civilization also had, although they had temporary residents in India, but still they had deep impact on our laws regulating water, because the most important part of their civilization was the natural law philosophy, that they used to give importance to the nature. They used to consider nature as a gift of God, and they used to worship and respect natural things. So they used to worship the trees, the groves, and the water bodies, earth, fire, wind, water, and sky. And from that philosophy, some enrichment took place in Hindu legal philosophy also. And we are very much aware about Varuna, who is considered to be the god of water. This is evident from our literature. And Indra is considered to be the god of thunder and rain. So with the passage of time, when we have heard the story of Mahabharata, and in Mahabharata, you might have seen Mahabharata on TV channels also. We could see that we were a society of totally dependent upon agriculture, as the population was also less at that time. So basically, inhabitation took place on the banks of the rivers at that time. Inhabitation took place around the natural springs, and the people were also interested in digging the wells, and artificial wells were also was a very important part of Mahabharata time. As agriculture was the main way of employment and the main way of fetching food also, so basically irrigation was done through the rivers only, and they were also using river for the purpose of navigation. So this quite clearly enshrines that the water was being used for the purpose of agriculture, for drinking, and for navigation purpose. Thereafter, when Jainism and Buddhism spread in India, around 6th century BCE. Both these both Jainism and Buddhism togetherly talked about conservation of the natural resources. Now the focus shifted from utilization of the natural resources, respect and worship of the natural resources, to conservation of natural resources, how we have to conserve them also, how we can preserve them also. So they started taking different kind of steps for that purpose. And uh, because at that time also, by the end, Jainism and Buddhism, it declined around 400 CE. The population was also increasing. So with the increase of population, the demand of water was also felt, and side by side, the water shortage was also a very important aspect. So as we were not doing any kind of business to that extent, we were not having any kind of barter system, doing some kind of business, or we didn't have any industrialization. So whole of the population, because was dependent upon your agriculture only, so there was also decline of soil fertility. So that also led to this philosophy of conservation, what we talk about, philosophy of conservation, that also led to the philosophy of conservation, and they stressed upon the how to conserve it. So in this way, there was a transformation from utilization to respect to conservation of water. Now, at the time of Gupta period, that is around 1000 CE, during this period, uh, there was worshipping of natural resources plus the conservation, both it was happening, and evidence is showing that they have their laws regarding it. They were also by the side interested in new technologies, how to preserve water, and evidences have been collected from the southern states, where it has been seen that they have formed and they use the technologies for the purpose of construct the dams and the canal system, right? Now, switching over from this historical perspective to the Hindu water laws, when we talk about the Hindu water laws, Hinduism is basically considered to be a living tradition. That is, we believe in karma, that is law, and dharma, that is order. And it is enshrined in various kinds of Hindu textures, like in Shrutis, in Samritis, in Artha Shastras, in Manusmriti, basically. And the most important aspect of Hinduism we see in Manusmriti, and we consider it to be a kind of very prominent Hindu scripture on which Hindu mythology is based. I just want to check, am I audible to everybody? Am I audible to everyone?
Yes,
Yes,
yes.
ma'am.
Okay, all right. Thank you so much. So when we talk about the Manusmriti, which was written around 200 to 100 BCE, uh, it talked about water laws very elaborately. Earlier, we used to take the steps, but we didn't have any kind of evidence related to some kind of scriptures which were directly dealing with water. Although we were talking about worshipping it, realizing its importance, how to conserve it, we were constructing the dams and the canals, but the literature was lacking in concrete laws for the preservation of water. But it was the time of the Manusmriti that different chapters of the Manusmriti openly talked about the water laws. So one of some of the famous chapters of the Manusmriti includes the chapter 8 and the chapter 9 of Manusmriti, where it was very clearly mentioned that the king should protect the public water. Public water means the water from the natural resources, and the king should also charge some fees for crossing water, that is the navigation. So whosoever is navigating through the water uh, channels, they should pay some kind of fee to the king also. And chapter 3rd talked about diversion and obstruction of water. It says that nobody will divert the natural flow of water, and will not try to obstruct, put any kind of impediments in the natural flow of water, right? Then we had chapter 4. chapter 9, chapter 8, and chapter 11 of Manusmriti, which togetherly talked about that there will be a particular concrete system of reprimands and punishments for those who are either responsible for polluting the water or stealing the water or diverting or obstructing its channels. So basically chapter 4, 9, 8 and 11 dealt with the penal kind of provisions for causing any kind of water obstruction, pollution. Then we had chapter 7. It dealt with destruction of embankments. Although enemy embankments could be destroyed, but if some king has constructed some embankments, some dams for the preservation of water, artificial storage of water, if somebody destroyed that, then there will be penalty for it. And the main thing which was used for demarcating the water boundaries between the villages, the boundaries between the villages was done through the water bodies only. That was the only way they used to demarcate between the two villages, right? Then if we go through the Arthashastra, this was a tenure. Arthashastra when written, it was a tenure when two things were very much prominent among in the society. The first thing was the king was exercising complete monopoly over the water. That I must clear it here that whatever law we have in the present century, be it your National Commission, be it your water policies, be it your Jal Shakti mission, be it your different kinds of act for the preservation of water, it has all been derived from the literature I'm talking about right now. And this literature is basically not formed as law. It was being practiced by the civilization that existed uh, in the history, and they used to practice as per their convenience. They used to do some practices related to water worship or navigation or preservation, and these practices became the customs which were followed by them from time to time, from ages to ages. And again these customs related, transformed into law, which we see at the moment in the form of the acts. So literature, aquatic literature, has played a very important role in the formation of the present legal policies, legal law related to the water preservation, right? So coming back to the Arthashastra, Arthashastra mentioned that two things were very much important in that society. The first thing was that king exercised complete monopoly over water. Here, I'm not talking about the underground water, because underground water was not a matter of concern uh, before our independence, as the population was quite satisfied with the surface water only, the surface natural resources. But all these surface natural resources were under the monopoly of the king. All the rivers, all the natural resources which were coming within the jurisdiction of a king. King used to exercise complete monopoly over it, and he used to pose some taxes, which is called as the water tax, on those who used to withdraw the water from these natural resources for irrigation purpose, for drinking purpose, which was installed by the king, be it embankments made by him, be it the natural resources on which he was exercising his monopoly, right? So this tradition is still being prevalent, that we pay the water tax. So we have, it is quite clear that still now we have the center and the state governments imposing tax on us. And at that time, because it was basically the time of princely states, so kings were exercising monopoly over water. And second point in this was the limited private ownership, that private individuals didn't have any kind of ownership on water, except the artificial wells they have made in their properties, or the tanks they have made in their properties, from which they used to which they used to mortgage also, and they used to sell water also for the purpose of fetching money, because at that time we didn't have any industrialization. So basically it was either the agriculture purpose, or it was your posing the taxes on water. Then, as the Mughals invaded during the uh, around the 10th century, there was some changes which took place in the water laws. There is a very famous book, uh, Islamic law principle book, we can say NAF, in which it says that they consider water to be God gifted. It is a gift of God. So they consider it that if it is a gift of God, it should be available to everyone. Everyone should have access to it. And this made a right also, which was called as the right to thirst. According to this right, what they wanted to say is that all the human beings, all the living creatures, be it human beings, be it animals, be it any other species, everybody has a right to satisfy their thirst from any water point which is available. So they basically were talking about use of water in a very harmonious way by the human beings and the animals as well. Sorry. Now, as the European invaded India, we all know that they invaded India for the business purpose, and East India Company, we all are aware about it. And uh, their main purpose is to set up industrial institutions here, and to use the raw material, and to at very cheaper prices, and to sell that raw material in their countries, and make use that raw material in making the articles, and then again sell in the countries, and thereby doing the business. Although it has very they have misused the property of a country, but on other side they also led to industrialization in the country. So now the shift of the Indian civilization, it shifted from agricultural to the industrialization process. So when they invaded India, two things impacted India to a great extent. Firstly, the industrial revolution that took place in England. It had a deep impact in India, and their culture. European culture also had a very deep impact in India. We all know that the present legal system is based upon the common law doctrine that is derived from English law. So we had a very deep impact on our legal system because of the European invasion in India. So the three major changes that they brought in our country includes there was a complete transformation from resource gathering and food production economy, the agriculture society, to a commodity oriented economy. Now we were more interested in industries, in barter system, in setting up small scale industries, in setting up household industries. Then the second thing they had impacted is on the long-standing social relations and customs. Whatever customs we were followed, they drafted those customs into laws. So this was also a major thing that happened during this period. And the third thing is, for them, commercial production became very much important, as they were totally business minded, and thus exploitation of the already existing natural resources was the side effect of it. They were not interested in conservation at all. So they exploited our natural resources. They impacted our customary laws. They made it into their legal as per their convenience. They changed it into the legislation, and they transformed India from agricultural society to a business society. Because of these kind of major changes, the natural resources started depleting, and there exist waterlogging problems and salinity problems to a great extent. They took some major steps when they entered our country. The very first step was that they exercised complete control over the surface water, and they were trying to regulate it through the common law principles, that is based upon equity, justice, and good conscience. They were trying to implant their law, which was present in England and India, and they were trying to regulate the water. They were trying to take the water under their control. Second is they were also landowners who were doing agriculture in India since time immemorial, they had their own riparian rights with respect to the canals which were flowing through there. Still, it is prevalent in India that if the small sub channels are flowing through somebody's natural sub channels are coming from some diverting from some rivers, and they are flowing through some villages, or they are flowing through somebody's agricultural land, their natural flow is not obstructed, but they try to change the flow of the natural course of water from, and thus they also infringed the riparian rights of the landowners. And the third thing is that now but they just left one thing totally relaxed, that is the groundwater. The groundwater, the undersurface water, the subsurface water, it was available to the landowners for unlimited access that they could use. But because we didn't have that much technologies at that time, how to make effective use of the groundwater, so they were very much aware about it, that it will be cumbersome process for the landowners who are totally dependent upon agriculture as their source of income. Now, the most major statutes which were formed during the Indo-European invasion, Indo-European civilization during the time of British regime in India, are the Embankment Regulation Act of 1829 and the Bengal Embankment Act of 1855. These two both acts talked about the protection and maintenance of embankments, the artificial storage of dam through the embankments, and the of water through the embankments and the dams. And it also talked about that the land can also be acquired for making these dams and embankments, right? Second most important acts are the North Indian Ferries Act of 1878 and the Indian Fisheries Act of 1897, which was talking about how to regulate the canals for navigation. Means they were trying to put taxes on the navigation, and they were also trying to put taxes, and they wanted to take the fisheries and the ferries in their control. So that was the second major, two major acts which they passed. The next one is the North India Canal and Drainage Act of 1873. It was also, this act was also regulating your irrigation, navigation, and the drainage. So drainage was the drainage system was included, which was a conspicuous feature of this act, which was not present in the previous acts. And they openly recognize the rights of the government to use and control for the public purpose the water from all the surface water natural resources, right? Then we had the Madhya Pradesh Irrigation Act of 1931, which was again supporting your North India Canal and Drainage Act of 1873, right? Thereafter, we have the Main Act, which we all know about. That's the Government of India Act of 1935. This is major in the sense that here he did division. This act has done division between the powers to be exercised with respect to the water resources between the center, that is the your Britishers, and the governor generals, which were regulating the princely states. So they empowered the center basically to take the decisions related to irrigation, canal, drainage, embankments, hydropower projects, water storage and navigation. And they left the conflicts related to water between the princely states to be regulated by the governor generals, right? Now, if we switch over to the post-colonial history of water laws, that is after independence, we have labyrinth of laws which are dealing with it. But the most important one among them is the laws which are related to your water. And the most important in this, which is still there, these all acts are still there, but with amendments which are coming up with the passage of time, depending upon the necessity of the society. And they are implemented they are implemented in whole of the India, and both the central and the state governments, they are supporting it. So the very first important legislation in this category is the Water Prevention and the Control of Pollution Act of 1974. This act is basically revolving around, as the name by itself is indicating, it is basically revolving around the preservation and prevention of water from pollution and how to control the use of the water also, so that it will be unanimously available to everybody. At least the minimum potable water which is required by an individual as his fundamental right to safe drinking water is available to him. Okay. So this particular act has constituted two major boards: the central and the state pollution control board. State pollution control board, uh, in different states of the country, are every state has its own state pollution control board, and we have one supreme, the central pollution control board, regulating all the state pollution control board. So these state pollution control boards have been given, depending upon the demography of their particular states, have been given wide powers to take different kinds of actions and to perform different kind of functions, such as, for example, establishing the quality standards for water consumption, to carry out research programs in the field of water preservation and water recycling. Then we have proper planning and investigation to promote cleanness of streams. We have Narmada Bachao and Ganga Bachao Abhiyans previously, and still they are moving. So these are under the state governments only, and state pollution control boards take proper check of it, and they have the proper liberty to establish to investigate so as to promote cleanness of streams and wells, and of course to control the pollution of water also. These boards are also being given the power of giving permission to the persons who are interested in setting up the industries in across the nation, but they have to take a certificate that the effluents their industry will be liberating will not cause any kind of pollution to the water, or it will not pollute the natural sources of water, and they will be having a proper way of sewage system, discharge of hazardous effluents from their industrial units. These boards are also been empowered to put some penal punishments to all the persons, to the particular individual or to a particular industry, be it by closing the supply of water to that industry, individual or a person or a group of persons, be it by closing the move of electricity, supply of electricity to them, if they are found guilty of polluting water in any sense. Right. Moreover, this central pollution control board, water pollution control board, is also responsible for levying the taxes on the consumption of water, and it is also at the discretion of the states, depending upon the water consumptions. Right. Then we have the Air Prevention and Control of Pollution Act, dealing with air pollution, Environment Protection Act 1986, Forest Conservation Act 1980, and which was amended in 1988, which is considered to be a very important amendment in the Forest Act. Then we have the Public Liability Insurance Act of 1981, which is imposing liability on destruction of any kind of natural resources. And we have the Environment Assessment Development of Projects 1994. Water Prevention and Control of Pollution Act of 1974 is very much supported by the Environment Protection Act of 1986. Because your Environment Protection Act of 1986, it talks about our environment protection, and water is considered in this, the section 2 subsection A of this Environment Protection Act of 1986. It is considering water to be a very important part of environment, and it also talks about interrelationship between water and human beings, and water and other living creatures like plants, microorganisms, and property, because we all know that water is very important or indispensable part of an ecosystem as well. Moreover, this act is also authorizing your central government to set up the standards for the quality check of the environment and for emission of discharge of environmental pollutants from any source. So this very well clarifies that we do have laws to regulate water, but not only we have the legislations or independent acts which are dealing with it, but we have other provisions also. And to talk about the most important thing in this is the Constitution of India, which is considered to be the parent act, which came into existence in the year 1950, and it has been divided into different parts. Part third of the Constitution of India, it deals with your fundamental rights. And as we all know that whenever fundamental rights are enforceable and justiciable both. So if any citizen of India is suffering from any kind of infringement of its fundamental rights, which are being given there from Article 14 to um, Article 14 to Article 27, uh, that person can straightway recourse the court under uh, Article 32 in the Supreme Court and under Article 226 in the High Court, filing the writ petition in violation of their fundamental rights. So when we talk about these fundamental rights, one of the most important fundamental right we have is the Article 21, which we say is the right related to the right to life. So when we talk about the right to life, that every person, every citizen of India has its right to life and livelihood. So we know that for a life, the most important component of a body is water. And that should be drinking water, because 75% of our body is made up of water. So right to life under Article 21 also includes right to water. So every citizen of India, and this right to life is also available to the aliens, that is the foreigners who visit India randomly. So they also have this right to water, which is a indispensable part of our right to life under Article 21, and which is in turn a part of our right to clean environment. So keeping that in mind, further under Part 4th A, which deals with the directive principles of the state policy, there are certain articles which have been given here in this portion of directive principles of state policy, which are although not enforceable in the court, but they're justiciable. And whenever somebody's directive principle of state policy has been infringed, uh, the states are duty bound to approach to have harmonious construction between fundamental rights and the directive principles of state policy. That means whenever a state, by any of its authority, for example, if it is a water act and the state pollution control board is going to make any kind of law or any kind of amendment has to be made in the water act, so that amendment which is being made, it should keep in mind that there should not be any violation of the fundamental rights, and there should also not be any kind of violation of the directive principles of the state policy of any of the citizen of India. So under Article 39 Clause B of the directive principles of the state policy, it is the duty of the state. Here when I'm using the word state, it means the country. That is the central government. So it is the duty of the state to secure that ownership and control of the material resources of the community is evenly done. So here when we talk about the material resources, the most important source that we are using today is the water. So whenever the center is going to make any kind of laws related to water regulation in the country, be it your surface water or be it your underground water, although there are very few laws regarding the underground water, but we have laws for the surface water. So they should be evenly distributed norms favoring everybody, all the states in the country, right? Then we have Article 47 here. Article 47 basically poses a duty upon the government of India that they should always strive for raising the standards of nutrition, as water is also part of our diet. So its standard should be enriched. We should get safe, clean drinking water, and also take steps to uplift the standard of living so as to improve the public health. So for that, if the center has to make some norms to put some kind of restriction upon the consumption of uh, intoxicating drinks except for the medicinal purpose, or consumption of drugs except for the medical purpose, which turns out to be which if used in excess can cause danger to the life, injury to the health. The state is freehold to make any kinds of laws related to it, right? Now, beside our rights, we citizens also have some fundamental duties related to it. And these fundamental duties have been given under Article 51, subsection A, clause G, where it is a fundamental duty to respect the natural environment. That is very much important.
Ma'am, please unmute your audio.
Ma'am, your voice is not audible.
Sorry. Am I audible now?
Yes, ma'am. Yes,
All
ma'am.
right. Thank you. So, as we know that uh, our Constitution of India is also affected by the Government of India Act of 1950, where it was demarcating monopoly over water between the British regime and the Governor Generals regulating the princely state. Based upon that, we have division of uh, various kinds of functions between the center and the state lists. Means there are two kinds of list under the Indian Constitution, and we have different kinds of issues, different kinds of aspects of economy over there, like education policies, industries, water policy and all. So they have been divided upon depending upon its national importance, and depending upon whether it is a national importance matter or a matter important to a particular state, who will be more effective to regulate it. Depending upon that, they have these all ingredients have been divided into two kinds of list. So depending upon that only, as far as the water is concerned, water has been put in the state list. Every state of the country, they have water as an important ingredient of their state list. That means the state is having the immediate power to regulate any law related to the water flowing within its territory, right? And if it turns out to be some intranational river dispute, if it is an interstate dispute, for example, the dispute like the river disputes, yeah, we have heard about it and we read about it. So here the states between whom this dispute is taking place, or the states among whom, they can be more than two states also, these states are the immediate authority to resolve it. The center will not have any interference in it. But if it turns out to be a dispute which has now taken national front, or it is a dispute between two countries related to water, our neighboring countries in India, then the center will interfere in the river dispute, although the matter is in the state list, right? So beside that, we have the River Boards Act also, which is made by the states, and the Interstate Water Dispute Act also, which is also giving states the supreme authority to resolve the disputes related to water, right? Now, as I was talking about, union can can interfere in the state list only when it matter becomes intranational or it is inter-country state river dispute, and it has been mentioned under entry 56 of list 1 in the Constitution of India, right? And entry 17, list 2, which deals with your state list of the seventh schedule of the Constitution, schedule 7, entry 17, list 2. It says that water, which includes everything, water which is supplied for drinking purpose, which is supplied for irrigation, which is supplied for canal, drainage, embankments, water storage, and water power. They are all the matters of the state list, right? And the second thing in this is we have one more article in the Constitution, that is Article 262, which state that when the state is solving their interstate river disputes, the parliament is empowered to make any law regarding it. If the state is passing a bill in their houses and sending it to the parliament to make a law to make certain changes related to the river dispute among them, and then the parliament can make the laws, and when the parliament will make law related to any interstate river dispute or interstate river valley, then the Supreme Court or any of the high courts will not interfere in it. So here the judiciary is not interfering, is not exercising its independence as far as the interstate river dispute is concerned. If a law is changed, is amended, and the parliament makes it. Now the question arises, what are judiciaries doing to protect our water? Like laws have been made, are some landmark judgments given by the Supreme Court of India, which is considered to be the apex court, which is responsible for protecting and preserving not only human life, but also the natural resources. So there are so many labyrinth of judgments being given, but I will just talk about few of them. The first one is the Subhash Kumar versus State of Bihar, 1991. In this case, the Supreme Court straightway held that the right to life includes the right of enjoyment of pollution-free water and pollution-free air for full enjoyment of life, right? And if any person feels that his right to full enjoyment of life as a citizen of India has been endangered or it has been impaired, that person can file a writ petition under Article 32 to the Constitution of India, right? Then we have the Vellore Citizens Welfare Forum versus Union of India, 1996 case. In this case, the Supreme Court held that although we follow the common law doctrine of England, that people have the right of very clean and healthy environment, but the people also have one responsibility here, that they will be they can also be penalized if they will cause any kind of water pollution, and that penalty which is imposed on the person who is responsible for polluting it, as consequence of which others have become the victim, they have been deprived of their right to safe drinking water, that penalty will be posed on two kinds of principles. So this case basically talks about two kinds of principle while imposing a penalty and giving compensation to the victims in case of water pollution. The first one is the precautionary principle, and the second one is the polluter pays principle. Those who polluted, they will have absolute and strict liabilities that can be taken from their personal properties also, and if there is any kind of degradation of natural resources. Then we have the Delhi Water Supply and Sewage versus State of Haryana. That is the case of 1996. In this case, very elaborately, the Supreme Court said that water is a gift of nature. Human hand cannot be permitted to convert this bounty into a curse and oppression. The primary use to which the water is put is drinking, and it will be a complete mockery if we will force the people to live on banks and remain thirsty. That means it was saying that the river has to flow through some territory, And when the river is flowing through some territory, the river should be used by the people living in that territory, be it for the purpose of drinking, be it for the purpose of irrigation, and we cannot deny the riparian state their right to have water, right? Switching over to the next case, that is of 1997, MC Mehta versus Kamal Nath. In this case, the Supreme Court held that a legal system which is based upon the English common law also includes public trust doctrine as a part of its jurisprudence, which put a trust on the state is the trustee of all the natural resources. Here, the state should act as a trustee, as a caretaker. He trustee of all the natural resources, and as a trustee, it is the responsibility of the state to ensure that the natural resources should be used for public purpose, and they should have beneficial enjoyment of it, unanimous beneficial enjoyment of it. Everybody should get benefit from it. So it is the duty of the trustee to protect the natural resources, and the natural resources should be for public use only and should not be converted for as a private ownership. That means be somebody a very on this industrial giant, they have no they cannot purchase the river. I mean to say that the natural resources should be used by everybody harmoniously. Then we have the most famous Narmada Bachao Andolan versus the Union of India of the year 2000. In this case, the Supreme Court held that water is the basic need for the survival of human beings and is a part of the right to life as enshrined under Article 21 of the Constitution, which says that every person is having right to healthy environment and to sustainable development, and it is the fundamental right. Okay. Now, recently, the government of India has been very much active in formulating different kinds of and renovating different kinds of government policies for water conservation. Because if we take a look towards the states of India, especially Punjab and Haryana, they are at the borderline of heading towards desert areas, because not only the surface water is almost negligible, about 10% there, but if we look at the groundwater also, it is also depleting, and moreover, which is depleted, it is very much rich in minerals, hazardous minerals, which is not fit for drinking. So keeping that in mind, the alarming situation in India, the national water policy, which was formulated in the year 1987, it has been changed, and it has been working very actively. This policy has been stressed upon time and again by different coming and going governments, and different kinds of changes have been made in this policy since time immemorial, so as to preserve the water, its quality. So some of the most important changes that have been brought in the year 1977 when it was introduced was, the very first one was to protect and to make very conjunctive use of the surface and the subsurface water, that is the groundwater as well as the water which is there through the natural resources. Secondly, the second point which they stressed upon was to supplement the irrigation, how the water can be used for irrigation, and what are the best practices which can be involved for the purpose of using less water in irrigation and recycling it also, right? Then the third thing they stressed upon was water conserving. Crop patterns should be introduced, that we know that we have, because we have 4 seasons in our country, we go for crop rotations, and that not only lead to our increasing the fertility of the soil, it also leads to, there are certain kinds of crops which takes very less water. So this crop rotation is also was a very important point which was insisted by the national water policy. Then the next one was conservation of irrigation and production technology. Water conserving irrigation and production technologies development should be done. Research should be carried out in this area. Then they also talked about raising the canal water charges also, so that the taxes which are collected, they should be used for the research purpose, for recycling the water. And Promoting user participation in canal management. If the private individuals are also interested in canal management, that could also be done. Now, switching to the next slide. This national water policy was amended in the year 2002. And when the amendment took place in the year 2002, two major changes were brought in this national water policy. First one was the public sector was included to play a very important role in it. Now, not only the government organizations started delegating its powers to the public sector also. If the public sector is also interested in playing an important part in, say, recycling of water or developing the technologies and the projects, the private sector was also given an upper hand. And secondly, this policy stressed upon the fact that the more attention should be paid to the already existing and running projects than developing the new ones, so that less money will be used, because to develop something new, more money is required. So already existing plants, water plants, they were stressed upon, they were technologies were introduced in them for proper recycling of water and conservation of water. Then we have the National Water Policy of 2012. And this policy straight away addressed the problem of water scarcity increasing in India. And it talked about water pricing and optimal use of water, because as the population was increasing, the demand of water is also increasing. So there are certain very major steps which were taken under this policy, and which includes optimized use of it, number one. Secondly, there should be perfect harmony between the center, state, and the local bodies, right? In terms of governance institutions, so that minimum quantity of potable water should be provided to them. Third is that ecological needs of the rivers should be determined. Rivers are meant to flow, so their natural flows should not be disrupted by the embankments to an extent that flood-like situation should take place by constructing artificial dams. Then navigation, basic purpose of water should be for navigation and for collecting the seafoods. That was also stressed upon. Then it was also stressed upon that our eastern and northeastern regions are very much rich in water sources, so they should be given more stressed upon, and the community should be sensitized. So these were some proposals. Then we have the Central Water Commission, which is working under the Jal Shakti Government of India, which is basically the amalgamation that took place in 2019 between the Ministry of Water Resource, River Development and Ganga Rejuvenation, and the Ministry of Drinking Water and Sanitation, and it is totally based upon your water policy of 2012. Then we have the National Water Mission. It is also a part of the Jal Shakti Mission. We have done it. And there are certain suggestions, although this policy has given so many suggestions, but there are certain suggestions which can be kept in mind, like effective recycling of water. Second is eco-friendly sanitation system should be adopted. Urban water supply system should be checked, because majority of population these days, overpopulation is in the urban areas. Then water efficient techniques and technologies should be adopted. Pilot project should be taken for water conservation, because it has become an alarming situation in India at the moment. Promoter of water regulatory authorities and tax charges should also be imposed. And awards should also be given for water conservation if it is carried by the private sector or the government institution. And effective irrigation practices should be adopted. So this is a brief about your aquatic legal literature. I hope, although I have not used any legal terms to an extent that you should not understand it, but I hope you will have a complete knowledge about what exactly is happening as far as your water laws and policies is taking place. Thank you so much.